We're a small group, so we'll try to be a little informal. So if you have questions as we go along, let me know. We have the very exciting topic of classifying employees. Try to make it as interesting as possible. It's actually a really good topic because it's a frequently litigated issue. So the Fair Labor Standards Act is one of the most common lawsuits that's filed in federal courts throughout the country. So we see those kinds of actions regularly. The Fair Labor Standards Act seems like it would be very straightforward, easy to comply with. It can get complicated, as you can see, and we're just going to talk about two aspects of it, which are these two issues. So we'll go through, and hopefully you won't have any problems and you will never get sued, at least under the Fair Labor Standards Act. So that, I still look like that, right? I'm getting a new picture, just in case. So the basic provisions of the Fair Labor Standards Act, it establishes minimum wage, overtime, law requirements. There's posting requirements, recording requirements, and child labor laws. So at the very basic essence of the Fair Labor Standards Act, you have non-exempt employees are entitled to a minimum wage and must be paid overtime at a rate of 1.5 times their regular rate for all hours worked over 40 hours a week. So that's the simple part, right? So it gets complicated when you are trying to figure out what the regular rate is, because that includes all sorts of remuneration to determine whether somebody is actually a covered non-exempt employee or not, which is what we're going to talk about. Also wanted to note that, given our audience, that religious organizations have to comply with the FLSA to the extent that they're engaged in ordinary commercial activities. So for example, religious schools or daycares or that sort of thing. So that's what the courts have said. Anyway, good topic for you all to know about. So common FLSA violations that we see are the very first thing that we're going to talk about is the misclassification of employees. So whether somebody's exempt or non-exempt under the statute, and whether somebody's an employee or an independent contractor. If they're an independent contractor, the statute doesn't apply. If they're exempt, also statute doesn't apply. So those overtime requirements and minimum wage. The other issues that we see are failure to pay overtime at all. A lot of times what we're seeing, especially now that people have their phones, is they allege that they're working off the clock at home, and the employer is not paying them for that. So miscalculating overtime pay, failure to keep records, and then improper deductions. So we're going to talk a little bit about that in the context of exempt employees. So firstly, most employers will classify positions within their organization. So you have FLSA classifications, which are that this position is exempt or non-exempt, so we know how to handle the position for payroll. Other types of classifications that are really employer created are you a regular full-time employee? Are you regular part-time employee, temporary employees, probationary employees? Notably, any of these classifications can be covered by the FLSA, and minimum wage or overtime do, right? So if you are exempt, an exempt classification means you get no overtime pay, you get no minimum wage, but because of the salary requirements, you will get paid more than a minimum wage. The exempt employees must earn at least $684 a week on a salary basis in order to be considered exempt. The job must fit into specific categories and meet a duties test in order to fit into that category. Of course, if you're non-exempt, you get overtime. You can either get a salary or hourly wage. You can earn any amount. You can work in any field, and you need to meet the duties test. So we're going to talk a little bit about the duties test. Yep.
So salary and overtime, how does that work?
Okay, so if you're a non-exempt employee, there's nothing that requires the employer to pay an hourly wage. You could still pay like a flat salary, $2,500 a week or something. But the person is still non-exempt. And so in order to, if they work overtime, you're going to have to convert that salary into an hourly rate so that you can calculate the overtime. But some employers do that. Yeah.
And that's a law, or hey, wink, wink, this would be nice to do for your people
To pay overtime for non-exempt employees.
for salary.
Yeah, I mean, if the non-exempt employee is paid a salary, then you have to pay overtime.
Fascinating.
Yeah. Okay. You're welcome.
I'm just,
Because you have to be exempt
yeah,
in order to, and to be an exempt, you have to pay the employee a salary and you have to fit into one of the categories that we're going to talk about. So you have to meet both of those requirements. So you do have non-exempt employees that could be paid a salary by an employer, but they don't meet that one of the tests that we're going to talk about. So in that case, you still need to calculate their rate for overtime and track all their hours.
I was trying to figure out when it would behoove an employer to pay a salary non-exempt person.
If the job is a hard to fill job, so you might, say, because we're having such a hard time filling this job, we're just going to agree to pay you $75,000 a year, and and we're not going to.
More than overtime to do it, kind of thing.
Yeah, or we give you overtime, so on top of it. So it just depends. It's usually just based on the market and the need of the employer.
This much money, and then if you work overtime, we'll give you per
Right.
I'm with you.
Yeah.
Thank you again.
Yeah. So like healthcare, for instance, is a really hard industry to fill, and they might be considered non-exempt, and so you might be paying on a salary basis. And I have some clients that are like that. They're hard to fill, and then you pay them overtime too. Wanted to mention at the outset the ministerial exemption. So the FLSA is not going to apply to ministerial employees of religious organizations. So these are going to be, obviously your ministers, your pastors, but also your teachers who are teaching religion and promoting or carrying out the religious organization's message and mission. With that said, your religious organizations employees that are not engaging in that kind of behavior as part of their job duties, so your custodial staff, your administrative staff, they will be covered by the FLSA. I looked at some cases involving religious organizations in preparation for today. So I saw a case where there were lay teachers, so just teachers that are teaching math. And, again, they're covered by the FLSA. There was one involving a individual who was a part-time pastor and a full-time executive director of a nonprofit affiliated with the religious organization. The executive director role was covered by the FLSA. Volunteers are also not covered by the FLSA, meaning you don't have to pay minimum wage or overtime. So, but to be clear, volunteers are, as the name suggests, volunteers. So not your employees who you direct to do, some extra activity on Saturday. Even if it involves, you can imagine a scenario where you have an employee in the gift shop for the religious organization who works the cashier, the register, and then there's an event on a Saturday and you want that same employee to work at the register, for some things that you're selling at the event, even if it's a charitable event. That's usually where we see the issue come up, where, you have a current employee who's directed to volunteer for some event. But certainly if somebody is volunteering freely for any type of event, even your own employees, then you don't have to pay them for that minimum wage or overtime. So by way of an example, we recently in our office organized a meal at the Ronald McDonald House. So, I invited everybody in the office, all of our employees to come to help make the meal, but made it very clear that it was volunteer only, so you didn't have to come. So that we didn't have to pay for that time if they did come. So we'll start with the exempt, non-exempt. And so to be exempt, you have to meet the salary basis test. So you have to be paid a salary. That's just one of the requirements for the exemption. And that means that they get a predetermined amount of compensation each pay period on a weekly or less frequent basis. It has to be more than 684. You probably heard that there was an effort by the DOL to increase that amount, and that was rejected by the courts. They didn't have the authority to do that. So we're still at 684. This amount can't be changed based on variations in quality or quantity of work, and you have to give them their full salary any week that the employee performs work, regardless of the number of days or hours worked. So, you have an exempt employee and they leave the office for 2 hours to go to a doctor's appointment. You can't dock, their pay for that. So there are some deductions that are permissible, and these are listed here for exempt employees. So when they're out for full days, for personal reasons, so they just take off because they want to go to Disney for a few days. You don't have to pay them for those days. Usually you're going to have some sort of PTO or paid time off or something of that nature. They're off 1 or more full days due to sickness or disability if you have a bona fide leave plan in place. So that's just, you have something in your handbook that you give out sick leave for these instances. Even if they have no leave left on the books, you don't have to pay. You don't have to, there are other deductions you can do offsets for jury witness fees. You can deduct from pay if your employees are suspended for disciplinary reasons, if it involves a major safety violation or workplace conduct. So in other words, a lot of times, like performance type issues, you wouldn't deduct from their pay. But if you have like major disciplinary infractions, you could do a suspension. And then, if the first week and last week, if you have partial weeks, you can deduct, and then also unpaid leave under the Family and Medical Leave Act, you can deduct. Any questions about that? This comes as a surprise to some people that you can't deduct from exempt employees, but generally, yep.
Like for instance, our teachers, Nalita, are they exempt? Are they categorized as exempt?
Yeah.
The teachers can take days because you have Christmas, you have
Yeah, but like
the
if
spring break.
they taught for the majority of the day and had to leave 2 hours early. We don't deduct that 2 hours, right?
No, we don't.
Yeah.
No.
So the effect of an improper deduction is you can lose the exemption status. So they could be considered non-exempt and owed minimum wage and overtime. There's a safe harbor provision in the regulations where essentially if you have this type of policy where they can report and you fix, then you would be protected from losing the exempt status. So in addition to the salary basis test, the employee has to meet one of the specific exemptions. So there's the executive exemption, the administrative exemption, the professional exemption, computer, outside sales, highly compensated employees. So we'll go through each. So the executive exemption, again, they have to be paid the salary, and their primary duty must be managing the enterprise or part of the enterprise, and the employee must customarily and regularly direct the work of at least 2 or more full-time employees or their equivalent, and they have to have the authority to hire or fire. So often somebody's classified as exempt executive, but they don't meet these last two requirements. So you might have even a director who has nobody that reports to them. And so they don't hire or fire, they don't have the reports. So they're not going to be exempt under this category. They might be exempt under the next category, which is the administrative. Okay. So the administrative exemption, again, they have to be paid a salary of $684 a week. The primary duty must be the performance of office or non-office manual work directly related to the management or general business operations of the employer or the employer's customers, and their primary duty includes exercise of discretion and independent judgment. So a lot of times we see that this last bullet's not met, that employers will assume that administrative personnel, so anybody who works in the office, administrative assistant and executive assistant, that they're performing, office work, but they oftentimes don't have the discretion or independent judgment to make decisions. So that's a common mistake in that classification. So if you think about managers and supervisors, so you might have a situation where you have somebody that's titled a manager, but they have no direct reports, and they don't have independent judgment. So there's a bunch of cases involving the Dollar General stores. The store managers were determined to be non-exempt because they performed functions like operating the cash register, closing and opening the store, stocking. They were called the store manager, but they really did the same duties as anybody else. They didn't have the ability to hire or fire. And, so the court found that they were hourly employees, subject to minimum wage and overtime laws. So it really doesn't matter what you call them. It's about, do you meet this test, either, in some form or fashion. There's also the learned professional exemption. So this is where your teachers will fall in, your doctors, accountants, lawyers. Again, they have to be paid a salary of $684 or more a week. They must have a primary duty related to work requiring advanced knowledge. The advanced knowledge must be in a field of science or learning, and the advanced knowledge must be acquired through a prolonged course of specialized intellectual instruction, so like a college degree. There's also the creative professional exemption. So this is for, again, they have to be paid on a salary basis, and their work has to be related to work requiring invention, imagination, originality, or talent. You also have the computer employee exemption. So again, paid on a salary basis or at an hourly rate of not less than $27.63 an hour. They have to be employed as a computer systems analyst, programmer, software engineer, or some similar position. And then it's very consistent of very specific as to what the primary duties must be. So you have to meet every one of these bullets, or you don't meet this exemption. So designing, developing, documenting, analyzing computer systems. So when I say meet every one of these bullets, one of these three bullets, these are ors right here. But you have to have one of those duties. And so what issue we see in this area is where an employer will classify any employee dealing with computers as exempt. And so your help desk employees, for instance, would not meet this exemption because they're not performing at this level, and they're not performing one of these duties, just because they're helping you figure out why your computer's not working. There's also the outside sales exemption, which again deals with, but this is for employees that essentially do sales outside your main location, so door-to-door sales. So that's that exemption. And then there's the highly compensated employees exemption. So this is anybody compensated over $107,000 and performs one of the primary duties of the other exemptions. They're considered exempt as well. So common mistakes in classifying an employee as exempt: treating all employees paid a salary as exempt, so without applying the duties tests. Making classification decisions based on job title alone. Like, so if the title is a manager, you just decide they meet the test, and that would be a mistake. Classifying all administrative staff as exempt, or all supervisors as exempt, or anybody who works with a computer. Those would all be mistakes because you have to apply the criteria. So my recommendation is that whenever you hire an employee, a new employee, to just do a check and make sure. So usually what we do, you have a job offer, and usually the job offer will specify whether they're exempt or non-exempt. And just doing a check, looking at the position, looking at the duties, and being sure that, yes, I'm confident in this decision. Looking at their pay, making sure they meet the 684, making sure that the job description matches says whether it's exempt or non-exempt, and that the duties line up, that there is some independent judgment, that there's some discretion, and that you can determine that through either the job description or what they will be performing as job duties.
Question, sorry.
Yep.
Number 4, so that would be they do the parentheses, they often do not customarily and regularly direct the work of at least 2 or more. So that's 80 hours a week that they are in charge of. Would that be correct?
So the statute doesn't define a full-time employee. Would likely rely on what the employer, considers as a full-time employee. Sometimes that's 40 hours, 38 hours, 32 hours. But a lot of times supervisors don't have 2 people that report to them and don't have the ability to hire or fire. They're really just supervising their work, right? You have the manager, even the head of the organization makes all hiring and firing decisions.
Gotcha. Thank you.
Yep. So in addition to misclassifying as exempt or non-exempt, you could misclassify somebody as an independent contractor when they're really an employee. So, there was, to determine whether somebody's an independent contractor depends on this rule that was published January 10th, 2024 by the Department of Labor. And these factors apply. It's not based on what your contract says. So you could have a contract that says you are not, I agree, I'm not your employee. I agree, I'm a 1099. That doesn't have any effect whatsoever. It's whether the person actually meets these factors or not. So the nature, and let's use an example that's pretty common. In the last class, we talked about an HR consultant. So an organization hires an HR consultant to come in and do a pay plan review, make sure that you're paying according to market, make recommendations for adjustments, and at the end of the contract, they'll just produce a report and recommendation to you. In that situation, looking at factor 1, the nature and degree of control over the work, the employer doesn't really have control over the work, right? So you're relying on the HR consultant to do the work at their own pace, use their own expertise, use their own supplies, and produce a work product at the end. We probably just give them information, right? We give them our job descriptions, we give them our pay bands, and then they go out and they might work on it 1 hour on a Saturday. They might work on it 5 hours following Thursday, but you just agree that in 8 weeks, we want the report. So in that instance, the employer doesn't have a lot of control over the work, right? It's actually the consultant who does. The individual's opportunity for profit or loss. In the consultant situation where they have many different customers and clients that they're working with, they have a great opportunity for profit, right? So that what they make is going to depend on how many, what they negotiate, and all of the different clients that they're able to sign up to do this type of work for, as opposed to, no, you just get a set salary. The amount of skill required for that work, in that instance, that's a skilled person who has expertise in HR, so that weighs in favor of being an independent contractor. The degree of permanence of the working relationship, again, it's a temporary relationship. You just sign them up to do one deliverable, maybe over an 8-week period. Whether the work is part of an integrated unit of production, again, whether it's, and really you think about it being a sort of a key component of what you're carrying out day to day. And in this instance, you're not an HR company, you're a religious organization or a school. You're not in the business of evaluating compensation. That's just not what you're doing. So all of those factors in that example weigh in the favor of that is an independent contractor. So I did want to note, and you may have seen some developments on this, but the rule that was issued, so what I just went over is called the economic realities test, and that rule was developed by the Biden administration, and it was intended to be a little bit broader to cover sort of the gig economy and more independent contractors, making them employees. The rule has been challenged in court, and it's up on appeal. And so just recently, I think this article is March 31st, so the last week or two, the new lawyers for the Department of Labor have asked the appellate court for continuance to brief the matter, so basically indicating that they may change the rule again. So at the end of the day, what we suggest is to just apply, these are actually the factors which are very similar to the rule I just showed you, but these are the factors that the courts have always applied to determine whether somebody is an independent contractor or not under the FLSA. Very similar to what we just talked about. Does the company have employees performing the same services as the worker? It's a little bit of a different of a factor. But ultimately, I like to give the example of a plumber to help you make that determination in your mind over whether somebody is an independent contractor or an employee. So if you think about a plumber and sort of looking at some of these factors, the plumber, you have a need for a plumber at your home. You have a pipe that bursts, and so you call the plumber, and what kind of nature or degree of control over that work do you have as a homeowner? Very little, right? So the plumber brings their own tools. They come whenever they're available. They bring their truck with their own tools. They take as long as they need. They have a special skill set and expertise that you don't have to do the repair. They have an opportunity for profit or loss because they're pricing everything. They requires a unique skill set. The work is, well, that's not a great example, integral to your business, but as a homeowner, you're not a plumbing business, right? Is the working relationship with the company non-exclusive? So one of the things you often want to look at when you're analyzing whether somebody is an independent contractor or not is, do they have other customers? Do they have other clients? Have they set up an LLC? So if you're entering into an independent contractor agreement where it looks like an employee, so it's with an individual, they have no insurance, they have no company, they don't work for anybody else, they just work for you. They're going to be coming in every day or part-time. You're supplying them all their supplies, the office, the laptop. Yeah, they're going to be considered your employee even if it's short-term, right? So even if it's a month, probably still your employee.
So can I ask you a question in a scenario?
Yeah.
I deal with building repairs painter that I've dealt with to do projects for the facility, he's interested in retiring eventually. He's like, man, I would just like to have, a couple days of work. I come to your facility, we come to an agreement. And as I'm going down that list, I'm not sure that we could consider him an independent contractor if he was there. Maybe he wasn't there regularly scheduled, but
Yeah.
periodically throughout the year doing just painting, and it would, I guess, if he billed me as a separate company, that might get, if he was providing his ladders and.
Yeah, it comes up from time to time where you have an employee of the company or organization who wants to end their employment relationship for what it could be retirement, it could be, I'm moving, for whatever reason, but then they want to stay on, or the employer wants them to stay on even and consult or finish up some projects. I mean, that pretty regularly happens. And so the key is to document what that relationship is and make sure the relationship changes to one of an independent contractor status. So, and that's tough because the person has worked for you for a long time, right? So you sort of are used to them showing up at a particular time, using all your stuff, but you can convert the relationship, but you really have to convert it. So
And they would have to have their own insurance and stuff.
yes,
That way.
yes.
Company.
Yeah.
And workers' comp and all of that stuff in place, and where they actually set up a company. But maybe the individual doesn't want to do that. I mean, in that case, I mean, you might convert the person to a part-time employee, a temporary employee, where they're paid on an hourly basis for whenever you need them. And that happens as well. And oftentimes I'm advising, well, gosh, if you just want them to do a reduced schedule because they want to slow down, they're still your employee,
Right.
So.
This is actually an outside contractor who's interested in becoming kind of like an employee.
Okay.
We would be interested in using him because of his expertise
Mm-hmm.
and availability. So not currently an employee that's going to retire, but he's going to retire from his company, and doesn't sound like he would keep his LLC or his business name and stuff. So anyway, it's a possibility in the future, and I was like, yeah, I'm not sure how to wade through that.
Yeah, I mean, you could do it either way. You just have to make sure you set it up properly.
Yeah.
I mean, you could certainly hire him as an employee and then pay him overtime, minimum wage and overtime, and track his hours. In terms of if there is a misclassification, those individuals who you misclassified as exempt or an independent contractor, basically how it works is they would file an FLSA lawsuit claiming I really was an employee of the organization and I wasn't paid minimum wage or overtime. And so the remedies available, if successful, if they prove that, are back wages and an equal amount of back wages as liquidated damages. So whatever they are able to prove that they weren't paid, for a 2 or 3 year period, and then you double that. And then if they are able to show a violation, the employer has to pay their fees and costs. So that's actually the fee provision, and because it's pretty easy for employees to get to a trial on these cases. So, there's usually a fact issue. You usually have the employee testify, I worked hours and I wasn't paid minimum wage or overtime. And that's enough to get them to a jury. So what you see is this lawsuit is very popular, one of the most popular, because it's fairly, I think, straightforward for plaintiffs' attorneys and employees. You can pretty easily get to a jury trial, and but oftentimes employers will settle these cases for a small amount of wages and fees is usually what we see. So a small amount, I usually see settlements in the neighborhood of $10,000 for these cases, so for fees and wages. So there's a civil penalty, $1,000 civil penalty, and that's when the Department of Labor is involved and they identify willful and repeat violations. So I think that's all I have. This one went a little faster this morning, this afternoon than this morning. There was a lot more questions this morning. Does anybody have any other questions? Because if not, you can have some free time, or you can ask me any labor and employment question you want. But because I do, Fair Labor Standards Act is one area, but we deal with discrimination, harassment, workplace policies. I mean, there's all sorts of whistleblower laws and all kinds of things we deal with in our practice. Yep.
So a question about the volunteers, asking them. So I feel like maybe there could be quite the gray zone with someone that comes and says, I work at a barn, so at the barn I would love to just do whatever I want to help you out on, Tuesdays or whatever, right?
Did you say a bar or a barn?
Barn.
Okay. Okay. I mean, I don't know that it matters, but I'm like,
Thank you, Michael.
okay.
Anyways, so, someone's coming in to help out.
Yeah.
And then, so how, should I just make sure that you verbally say, hey, would you mind doing, is this something that you would like to do? So I'm not being the guy that's like, you're a volunteer, but I'm ordering you around or bossing you around.
So are these individuals that are your employees who are volunteering? Oh, no. I mean, if they're just, volunteering.
And then they're volunteering, they can say no if they want to.
Yeah.
as long
Do you
as
have
they-
like volunteer forms or anything of that nature? Yeah.
Yeah.
I mean, it's good practice to have on the forms that, that they're volunteering and expect no compensation. And
It just gets tricky when there's an employee that then you kind of hint to encourage that.
yeah, when they say, and then they claim that they were coerced, they said it was voluntary, but it's really not. Like, I know my boss, and if I didn't show up, I would have gotten in trouble. So,
Okay.
yep.
Similar situation, like we have our hourly employees, local hires. On a Sunday, we had a field trip, and some of the hourly employees went. And then after the fact said, do I get paid for being there on Sundays?
Yeah, I think in those instances, it's really important, like when the event's coming up, to send out an email to your employees saying, we have this event, the field trip, and here are the details. You're welcome to volunteer, but you are by no means required to attend. And just doing that, I think, makes it clear, and probably see that a lot of your staff don't show up. And if you do want them to come, you're going to have to pay them or require them. Because in my own office, we have client events, and the staff is expected to come, to certain events, or not all of them, but and we pay them for coming, even if it's a lunch or what have you, because we needed their support with registration or what have you. But we always make it clear up front, the community events that they're welcome to come to versus what they're required to come to, and they'll be paid for. Yep.
So if you have an event and once it has something to do with team building, something to do with the job, you have to pay them.
Mm-hmm. Yep. Yeah, there's sometimes it gets a little, even with if you are paying for, a lot of employers will pay for training or even college classes, and that's not considered to be hours of work that's compensable if you're not requiring it, right? It goes back to it's just being totally voluntary and extra. But certainly if it's training for your job, yes, that's hours of work that they have to be paid for.
Are there rules for compensation for travel to such education things?
Yes.
Interesting. Okay.
So, well, there's travel rules generally. So generally speaking, your time to and from work is not compensable. So it's under the Portal to Port Out Act. My recollection is, because there's very specific regulations on this, but if you're traveling, you're a non-exempt employee traveling from place to place during the workday, your regular workday, then that's compensable. So like sometimes you have, work sites, like if you have construction workers and you're going from different places, that going from one work site to the other would be compensable.
So in the camp industry, there's this big thing held once a year, and those situations would probably fly somewhere.
Mm-hmm.
Then the camps, whether it's Kalaka, Nasoka, ICC, whatever, or any of the other camps in the North American Division, usually they're bringing people along. Those type of things are encouraged to be compensated for, or just be strictly on. Well,
Yeah.
if you're told to be there, then you get paid, or hey, if you want to be there.
So if they're staffing those camps, so they're not volunteering to go to one of these camps, they're employees. Yeah, they're gonna work at the camp, and you're gonna pay them.
So like
And but
being
they
there.
and then they have to fly a plane. So the rule is if the flight time is during their regular hours of work, that you count it. And if it's after hours, I believe that this is right, you don't count it. But we want to check the regulations. So, but my recollection is that anytime that you're traveling during those regular hours of work, that you're supposed to pay. But remember, your work hours might be different in the situation where you're like a camp counselor, right?
Yes.
Where you're, so, and then too, I want to mention in the traveling scenario, like any downtime that you have, so you're at the hotel, and not expected to work, like you don't have to compensate for that time, even though you're not at home. Any other questions?
So another question on the independent contractor.
We're crushing this, dude.
Yeah.
We're participants.
That's
Yeah.
right.
You're.
There's a lot of projects going on, and it's nice when you find a contractor you can trust and takes care of it. Is there any problem with just like continuing to use them for projects, as long as it's like contract or a different contract per project?
Yeah, you can use.
Show some separation.
Yeah, you can use contractors on a long-term basis,
Yeah.
but you just want to. So that would be one factor tending to show, because you have that long relationship, that maybe they could be an employee. But if all the other factors go towards being an independent contractor, so they still have their own company, their own equipment, they still show up when they want, and have their control over how the work's being done, then they're still an independent contractor.
And there's no time limit on independent contractors.
No.
Indefinitely.
No, I mean, you see it in the construction context. I was talking to a friend. I actually live in Gainesville, and how long it takes to build projects, out at UF. I think they said their project, the one she's working on, is through 2030. So it's the same contractor. So sometimes you have those long, and the IT world too, it takes a long time, a lot of times, to implement IT infrastructure for large organizations.